Continuing with the statute of frauds, there is what we call an executor administrator provision, which applies to promises to answer personally for duties of decedents. Decedents are those people or persons that have died. So in other words, it's very similar to the situation where we have a third party that agrees to pay the debt of another. And remember, that contract has to be in writing. So the example that I gave is if I owe you some money and my mother decides to or agrees to pay my debt for me, then that would need to be in writing. Well, if she made that promise and I died, then that would also need to be in writing. So in other words, the executor or the administrator of an estate, once a person dies, there's something open called an estate, and there's usually an executor or a personal representative that represents the estate. So any promises made to answer personally for those duties that belong to the decedent, to the person that died, then obviously that has to be in writing. Also, marriage provisions. This really applies to promises made in consideration of marriage, but not to mutual promises to marry. We don't see that very often nowadays. That's a provision that's been left over really from older times. But if there is a promise made in consideration of marriage, then obviously that has to be in writing. The examples that we do have nowadays that still survive would be a prenuptial agreement, for example. So that's a promise made in consideration of marriage. So that needs to be in writing. A postnuptial agreement would also be another example. So that would also need to be in writing in order to satisfy the statute of frauds. Land contract provisions, we already talked a little bit about that, but obviously anything that deals with any transfer of rights, privileges, powers, immunities, or really anything that has to do with real property has to be in writing. And that's for obvious reasons. We don't want people to take advantage of other people when we're talking about the transfer of land. There's also something called a one-year provision in the statute of fraud, and this applies to contracts that cannot be performed within 1 year. And under that, there's a couple of things that are really important. Number one is the possibility test, and the criterion is whether it is possible, not likely, for the agreement to be performed within 1 year. So really that's what we're looking at. Is it possible to be performed within 1 year? We're not going to look to whether it's likely. We're going to look to whether it's possible. And then the other important factor is the computation of time. The year runs from the time that the agreement is made. So that's very, very important. An example of this would be in a construction contract. So if we enter into a construction contract and it's not possible for me to complete construction within 1 year, then that contract needs to be in writing. If it is possible, then that contract may be enforceable even though it's not in writing. Full performance by one party makes the promise of the other party enforceable under the majority view. So, let's say that we're, again, and here we're talking about the 1 year provision again. So let's say that one party is able to fully perform within the year, but the other party does not or cannot. So that promise is enforceable under the majority view. Sale of goods. We had a chapter on the UCC and the sale of goods in general, but the sale of goods, if we have a contract for the sale of goods for the price of $500 or more, then that needs to be in writing in order to be enforceable. There could be an admission, for example, an admission in a pleading or any type of testimony or in court that would make the contract enforceable for the quantity of goods admitted. So that's also falls within the sale of goods. So even though it may not be in writing, but if there is an in-court admission or an admission in the pleadings as to a specific quantity of goods. So for example, if I sue you saying that you owe me for 5,000 pounds of tomatoes that I purchased from you. Well, that would be an admission in a pleading, and it may be enforceable for that quantity of goods. Specially manufactured goods. An oral contract for specially manufactured goods is enforceable. And by specially manufactured, we mean, let's say that I have a chair, a specific chair that I want you to make for me. And so I order it from you, and we're dealing with special made items. So whether it's a specific type of furniture, specific type of window, any good really that's specially manufactured, then even though the contract is oral, it would be enforceable. And again, we're talking under the UCC, right? So under the Uniform Commercial Code, under Article 2, which deals with the sale of goods. What about delivery or payment and acceptance? Well, any of those really validate the contract only for the goods that have been accepted or for which payment has been accepted. So that would be another exception to that. This next slide here, and it's actually in your book, it's an overview of the Statute of Frauds. Talks about the types. On the left-hand side, we see the types of contracts that fall within the Statute of Frauds. And on the right-hand side, we see some of the exceptions. Remember, I always talk about that. That's what makes law so complex, is that we have rules, we have exceptions to the exceptions, and sometimes we even have exceptions to the exceptions to the exceptions. For purposes of this class, just in general, in an undergraduate law class, we don't get into a lot of exceptions or exceptions to the exceptions. Those are the types of things you would see in law school. But I do want you to be aware that they're out there. And in fact, in this particular slide here, you get a brief introduction to some of the exceptions, right? We're not going to talk about exceptions to the exceptions, but understand that they're out there in many different areas. And that's what makes things very complicated. What about modification or rescission of contracts within the Statute of Frauds? Well, oral contracts that modify existing contracts are unenforceable if the resulting contract is within the Statute of Frauds. So in other words, if we have a contract for the sale of real property, then any oral modification is not going to be valid. The modification has to also be in writing, just like the underlying contract has to be in writing. And that would be true of any of those contracts that fall within the Statute of Frauds. So really, your first analysis is to look and see whether the contract falls within the Statute of Frauds or within one of the exceptions to the Statute of Frauds. If it falls within the Statute of Frauds and there is no exception, then any modifications have to be in writing. Cannot be oral, or the court will find that to be unenforceable. How do we comply? So what are the methods of compliance? Well, when we talk about general contract law, the writings or the record must, number one, specify the parties to the contract. So we need to identify the parties. Are they two individuals, two entities, an entity and an individual, a trust, whatever, whomever the parties may be, have to be specifically identified so we know exactly who the parties are to the contract. The next thing is we need to specify the subject matter and essential terms of the contract. So for example, if it's a contract for the sale of real estate, then we need to specify that it's a real estate contract or a purchase and sale agreement for real property and have the essential terms. In other words, we need to identify the specific parcel of land that is being sold. We need to have a time frame. We need to have a price. So that's what we mean by essential terms. And it also must be signed by the party to be charged or by her agent. In other words, if I want to enforce a contract against you, you must have signed the contract. Or in this case, as the slide mentions, your agent, someone that's acting on your behalf. if I'm the only one that signed the contract, then you can enforce the contract against me, but I can't enforce it against you because you didn't sign it. So that's why it's very, very important when you're dealing with any type of contract that you obtain the signatures of all of the parties to the contract. If you're missing any of the signatures, that could be a problem, because the party that did not sign it can raise as a defense that they did not agree to the contract. They never entered into the contract. Even though it identifies them as a party, they did not sign it. So that's got to be careful with that. You don't want to give somebody defenses that they otherwise would not have. All right, we're back to sale of goods here. Again, anytime you see sale of goods, remember you are under the Uniform Commercial Code, and you're under Article 2 of the Uniform Commercial Code, which has very specific requirements for contracts. So under the sale of goods, it provides that a general method of compliance for all parties, and there is an additional method of compliance for merchants. Remember that UCC makes a distinction between transactions between two consumers, between a consumer and a merchant, and a transaction between two merchants. The transactions between two merchants, we're going to hold them to a lower standard, meaning since they're merchants, the law assumes that they are sophisticated business people. And so we are going to place less restrictions and less formalities on their contracts than we will in a contract between two individuals or between a merchant and an individual. We're going to hold those parties to a higher standard, and we're going to require more clarity, more specificity, and just better contracts in general. So again, under the UCC, the writings or the record must be sufficient to indicate that a contract has been made between the parties. And again, remember, this doesn't have to be formal. I mean, I can write it on a piece of paper. I can even write it on a napkin, and that would actually be enforceable as long as it's in writing and it's sufficient to indicate that the parties intend to enter into a contract. Again, just like with under the common law, it must be signed by the party against whom enforcement is sought or by her authorized agent. So again, if you're trying to enforce the contract, then the other party must have signed the contract, or you're not going to be able to. Now here's the difference between a contract for the sale of goods. It must specify the quantity of goods to be sold. So if I'm selling you cars, for example, the contract must say how many. Is it 5 cars? Is it 100? Is it 5,000? It needs to be in the contract. That's one of the essential terms under the UCC. Also, there must be written confirmation, or the other way around, actually. So when we're talking about written confirmation, and again, we're talking here as between merchants, so two businessmen. And merchants are people that engage in a particular line of business, that sell a particular type of good. So for example, if I sell tires, I'm a merchant. If I sell paint, I'm a merchant. So written confirmation that is sufficient against the sender is also sufficient against the recipient, unless the recipient gives written notice of his objection within 10 days. So that's the rule. So if I'm the sender, let's say I send you an email that basically says, hey, this is to confirm that you're going to sell me 500 cars at $10,000 each. That's enough to create a contract unless you, the person receiving the email, gives written notice that you object to that and you have 10 days to do that. If you don't do it, in other words, we're going to assume that that's a valid agreement. So if when you receive the email, you look at it and you say, wait, I never agreed to sell that many cars, or I never agreed to that price, you have to actually reply to that email and say, hey, I object. That wasn't the agreement. This is what we agreed to. So when you're talking, if you're a merchant and you're dealing in the sale of goods, You have to be very, very careful when you do receive an email confirmation that you either accept it or reject it. So this is one of those situations where silence is going to be used against you. So we've been talking about the statute of fraud. So what happens if there is non-compliance? So let's say that a contract needs to be in writing and it's not. Well, an oral contract within the statute of frauds is unenforceable. So for example, if we enter into an oral contract for me to sell you my house, then that's not enforceable. So, and remember, when we're talking about enforceable, really, it's not an issue unless one of the parties has an objection. So let's say that I agree to sell you my house for $1 million, and you say fine, and we never put it in writing, okay? And I actually sell you my house, and you actually give me $1 million. Well, who cares, right? Because now we really don't need, we never had, I mean, I guess we had an oral contract, but under the statute of frauds, that contract is not enforceable, but it doesn't matter because I sold you my house and you gave me the $1 million. So really, it only becomes an issue when there's a problem. So when one of the parties breaches the contract, then it's a problem. So in my example, let's say that, you say, okay, you show up at closing and you have the $1 million, and I say, you know what? I changed my mind. I'm not going to sell you my house. Well, at that point, now you're going to have a problem because that agreement is not in writing, so it's not enforceable. You can't go to court. If you go to court and you try and enforce it, I'm going to file a motion to dismiss, and the court will throw that out. You're not going to be able to enforce it. What about full performance? The statute does not apply to executed contracts. And that's the example that I gave, right? If you agree to something and you do it orally and both parties fully perform, then that's my who cares example, right? I mean, it's been fully executed, so it doesn't matter. Restitution is available in what we call quasi-contract for benefits conferred in reliance on the oral contract. So let's say that we entered into an oral contract for me to sell you some commercial property, okay? And we never really entered into a written agreement, which under the statute of frauds, it needs to be in writing. And let's say that you spent $100,000 doing your due diligence, and you decide, you know what, I do want to buy the property. And when you tell me you're going to close, I say, you know what, I'm not going to sell you the property anymore. So then at that point, we have what's called a quasi-contract, which legally what that means is we never really had a contract, but the law is going to imply that we had one. And the reason being is that, you detrimentally relied on my oral contract or on my promise, right? I told you that I was going to sell you my property. Because I told you that I was going to sell you my property, you spent $100,000 doing due diligence. So now you're out $100,000. So now it'd be unjust, it would be unfair, it would be inequitable for me to say, you know what, I'm not going to sell you the property. So the court's going to say, no, not so fast, right? If you really did not mean or want to sell the property, you never should have agreed to it, and you knew they were going to do due diligence, you knew they were going to spend money, so you should have said something before. So that's called restitution. So in other words, I would have to pay you, I still don't have to sell you the property, but I would have to pay you your $100,000 that you spent doing the due diligence because of the promise that I broke. And so that we call that restitution. And the idea with restitution is to place you or put you, the innocent party, back in the situation you would have been in had I not ever lied to you. And I guess lie's a bad word, right? Because there's a lot of different circumstances. Maybe I really did mean to sell you the property, and in the meantime, something else happened that I changed my mind, right? So lie's not the right word, but the idea is to put you back in the situation you were in before we entered into the oral agreement. So, the situation you were in before is you had not spent the $100,000. So if I pay that back to you, then in essence you're in the same situation you were before, and so that's what the law is trying to do, and that's what we mean by restitution. Promissory estoppel. It's a related concept. Oral contracts will be enforced where the party seeking enforcement has reasonably and justifiably, and that's key. Both of those are key. Reasonably and justifiably relied on the promise, and the court can avoid injustice only by enforcement. So let me give you an example of that. Let's say that, and I may have given this example in class already, but it's the best example that I could think of. Let's say that I'm an employer here in Florida. You live in New York, you come down here for vacation. Somehow we meet each other, we start talking, and I realize that you're in my line of business. And I say, hey, you know what? I would love to have you as part of my business. So, if you come down here to Florida, I will actually offer you a contract for a year for $300,000. And after that year, we'll see what happens, whether we renew it or we decide, whatever we want to do. So in essence, I just promised you a job, and I promised you a job at $300,000. So you go back to New York based on the promise that I made. You sell your house and you move to Florida. You move your family to Florida. And when you get here, I tell you, you know what? Nah, the job's no longer available. So you could actually sue me for promissory estoppel, right? So it's an oral contract. I promised that I would give you a job for $300,000, and you reasonably and justifiably relied on that, right? I mean, you knew that I had a business, so it was reasonable for you to believe that I had made an offer. And in reliance on my promise, you sold your property and you moved to Florida. So the court can only avoid injustice if they enforce that promise. So in other words, the court can't force me to hire you, so I really don't have to hire you, but I have to pay you the $300,000 that I promised. So, and I will likely also have to pay you for any damages that you suffered as a result of my promise. So, for example, the property that you sold in New York, if you took some type of loss or there was some other type of consequential damage that you suffered, I would likely be liable for that as well. So you have to be, as an employer or as a business, you have to be very, very careful with the promises that you make. And that's what's always good practice, to have everything in writing. That way you don't get into trouble. I'm going to talk a little bit about the parole evidence rule. It's actually a very, very interesting rule. Here's what the rule means legally, and then I'm going to explain it. In essence, it's when the parties express a contract in writing that they intend to be the complete and final expression of their rights and duties, evidence of their prior oral or written negotiations or agreements, of their contemporaneous oral agreements that vary or change the written contract are not admissible. So in other words, once you and I enter into a final contract, once we sign that contract, then any other prior agreements, prior negotiations, or even contemporaneous negotiations are gone. We say that they merge into the contract. So in other words, usually what happens is whenever you're negotiating a contract, there's a lot of discussion that goes back and forth. A lot of times there's emails that are exchanged, there's promises that are exchanged. And really that's just part of the negotiation process. So you may offer a promise, and I may say, no, that's not good, but let's do it this way. So I'll send you in essence a counter offer. Well, all of those negotiations are not enforceable once we have a signed agreement. So you can't later go back to prior promises or prior agreements and try to change or somehow say that the contract that you signed means something different than it does. So you cannot bring what we call extraneous or outside documents to interpret the document that you actually signed. So that in essence is the parole evidence rule. So if you have a contract that is clear, is not ambiguous, then you cannot bring anything else, any other type of agreement or writing or anything to try and say that what the contract actually says is something different than what was meant. So that's the parole evidence rule in a nutshell. Very, very important rule, used a lot to keep evidence out. I've used it myself in court several times. Sometimes, usually when this comes into place, people are fighting over a contract and they're trying to say, well, this person actually agreed to X, Y, and Z, and here's a document where they agreed to X, Y, and Z. And I'm going to say, Your Honor, the parole evidence rule will not allow you to look at that document, because if that was important to them, it should have been in the contract that they signed. So the court is only allowed to look at the contract that was signed. Now, the exception to that is if the contract is not clear or if the contract is ambiguous. So here are some situations where the rule does not apply, right? So number one, a contract that is not an integrated document. So what that means is most contracts will actually have a clause or provision that actually says this is the entire agreement between the parties and all prior agreements are extinguished, and this is the only thing that's before the parties. If a contract does not say that, and if a contract actually references another contract, then we say that that contract is not an integrated document. So in other words, at that point, you could use other documents, in particular, if the contract references other documents. A situation where that happens a lot is in construction contracts. In construction contracts, many times there will be, especially what we call AIA contracts. Those are, the Architectural Institute has actually come up with some forms that are used and widely accepted within the construction industry. And so what happens with those types of contracts, then a lot of times they will reference other contracts or other forms. And so those would not be integrated documents. And by integrated, what we mean is that there's only one document and we can't look to anything else. Correction of a typographical error. So if we're trying to correct a typographical error, then the parole evidence rule would not apply. And that one's just kind of obvious, right? If we're trying to show that a contract was void or voidable, right? And we already discussed situations where that would apply, then the parole evidence rule would also not apply. If we're trying to show whether a condition has in fact occurred, that's another situation where the rule would not apply. Or if we're trying to show a subsequent mutual rescission or modification of the contract. If that's the case, then obviously the rule would not apply, because we would need to look at those documents, right? We need to look at, if there's a rescission or if there's an amendment or modification to the contract. Well, now we have to look at other contracts. So those are the situations where they do not apply. Now, when we're talking about the parole evidence rule, supplemental evidence may be admitted by the court in certain situations. And by supplemental evidence, we mean either additional documents or emails or letters or other things that are not in the contract. So for example, course of dealing. So the previous conduct between the parties may be used to show as supplemental evidence what the intent of the parties was. Also, usage of trade. So if there's a practice that's engaged in by the trade or the industry, a widely accepted practice, then we may also be able to bring that. And I keep saying may because it depends on the situation, and it also depends on the judge. Those are the types of calls that judges make. Course of performance, so conduct between the parties concerning performance of the particular contract, that may also be allowed. And any supplemental consistent evidence. So again, anything that's consistent with the terms of the contract itself. So here's a chart. It's in your book. It actually kind of gives you a step-by-step process to tell you when the parole evidence rule applies and when it doesn't apply. If the parole evidence rule does not apply, that means that the evidence that you're trying to bring in is admissible. In other words, the court or the jury can see it. If the parole rule evidence applies, then the evidence is not admissible. So I'm not going to go through each of the steps there, but it actually gives you a pretty good format that you could follow to see when it does and does not apply. But those are the right questions that you need to ask. What about interpretation of contracts under the parole evidence rule? Well, the ascertainment of the meaning of a promise or an agreement or a term of the promise or the agreement, there are certain rules of interpretation that apply. And again, whether we're talking about the whole contract or a part or a term, usually when you're talking about interpretation of contracts, most of the time we're talking about interpreting a clause or a term within a contract. So there are certain rules of interpretation that need to be followed. And all of those, and some of those include the following. So for example, all the circumstances have to be considered, and the principal purpose of the parties is given great weight. So in other words, we're going to look at everything. You can't do things piecemeal and only pick what favors you or what you want the court to look at, right? We got to look at all of the circumstances. And again, and what the court is going to give the most weight to is what was the intent of the parties? What did the parties mean? Usually what happens when you're in this situation is because there's a term in the contract, or maybe the contract itself, if it was poorly drafted, is not clear. And so what the court is trying to do, the court is trying to determine what did the parties intend to do. And so that is why the purpose of the parties is going to be given a lot of weight. The other thing is that a writing is interpreted as a whole. So you can't pick and choose. A lot of non-lawyers and a lot of clients of mine, a lot of times will come and say, well, look at this section. This section says X, Y, and Z. But you can't do that. You got to look at the contract as a whole and then try and determine the meaning as a whole. You can't just take things out of context and take just one section and ignore the rest of the contract. Commonly accepted meanings are used unless the parties manifest a different intention. So in other words, we're going to give words their ordinary meaning, right? We're not going to try and give a different meaning to words unless the parties intended for it to be that way. And if the intent is that way, for certain terms or clauses to be interpreted a certain way, then that should be in the contract. Otherwise, we're going to give words just their ordinary dictionary meaning. Wherever possible, the intentions of the parties are interpreted as consistent with each other and with course of performance, course of dealing, or usage of the trade. So again, we're going to assume that the parties are commercially reasonable people, and their intent is consistent with, in essence, the purpose of the contract, and we're going to look to see what they've done in the past, how they've dealt with similar situations, and we're also going to look at what do other people in the same line of business do. How do they do things if they're faced with this situation? So those are all the types of things that courts will look at to try and interpret a contract or a term when it's ambiguous or unclear. Technical terms are given their technical meaning. So again, in construction contracts, for example, there are a lot of very technical terms. An example of that would be substantial performance. That's a technical term. What does that mean? Well, we're going to give it the meaning that that term has in a construction context. And that's true of any area, right? So medical terms that are technical, we're going to give them the meaning within the medical field. Specific terms are given greater weight than general language. So if there's a clause that deals with a particular situation specifically, we're going to give more weight to that than to language that is just general in nature. Separately negotiated terms are given greater weight than standardized terms or those not separately negotiated. So in other words, if you're using a form contract and you changed some of the language and not the rest of the language, we see that a lot in real estate contracts where the parties will change some of the terms but will leave the other terms just as form language. In other words, they're the same in every single contract. We're going to give greater weight to those terms that were negotiated by the parties and less weight to those terms that are just standard or part of every contract or something that everybody uses. The order for interpretation is express terms. So the first thing the court's going to look at, the express terms. In other words, what does the contract say? It's the first thing. The second thing that the court will look at is course of performance. So how have the parties acted towards each other as it pertains to this contract, right? What have they done in the past? Which is really course of dealing, right? How have the parties dealt with similar situations in the past? And the last thing that the court will look at is usage of trade. So how do other business people or individuals in that same line of business, how do they normally do things? So those are the types of things that the courts will look at. And a lot of times you need experts to make those determinations or to provide that testimony to the court, right? Because the court, the judge is not an expert in every field. So normally you need to bring in an expert that says, hey, in the car business, this is how we do things, right? Or in the manufacturing business, this is how we do things. And so that's how the court determines how things are done or what's usage of trade. Now, where a term has several possible meanings, the term will be interpreted against the party who's applied the contract or term. So in other words, if you drafted the contract, if there are any terms that are not clear or any terms that have several meanings and you didn't clarify which of those meanings apply, then those terms are going to be interpreted against you and in favor of the other party. So you have to be very careful. What I do in my contracts, every time I draft contracts, I always put language in my contracts that says both parties participated in the drafting of this agreement and it shall not be interpreted against either party. So that's how you get rid of that problem. So there's always ways around it. And we're actually going to finish off this chapter with the last couple of bullet points here, which is written provisions are given preference over typed or printed provisions, and typed provisions are given preference over printed provisions. Okay, so to explain that, printed provisions, the reason why those are the ones that are given the least weight is because usually those are just pre-printed forms. And so those are rarely negotiated. So since that has not been negotiated, then we give those the least amount of weight. Then the next type of higher, I guess the next step in the hierarchy would be type provisions. So that means that we now added to that form contract and added to the printed provision, we added typed provisions. So if there's a discrepancy between a typed provision and a printed provision, the courts will usually go with the typed provision. And if there is written provision, and so we'll see a lot of that sometimes. So some contracts will usually have all three. And so we'll have printed, again, the form that everybody started out with. We'll have some typed language that somebody added to the contract. And a lot of times we'll have provisions that are crossed out and somebody handwrites certain provisions, or you don't necessarily have to cross it out. A lot of times you can handwrite provisions. Well, those handwritten provisions will be given more weight than anything else in that contract. So if there's a contradiction between a written provision and a typed or form provision, the written provision will always prevail. And again, I shouldn't say always, but more than likely will prevail. If an amount is set forth in both words and figures, and they differ, the words control over figures. We see that a lot in mistakes that deal with price. So a lot of times somebody will put $100,000, and usually the way the contracts are written, you write them out in words, and then in parentheses you put the numbers. And I've seen this in contracts where sometimes, it'll say $100,000, and then in parentheses, it'll have the numbers for $75,000. So when you have a contradiction like that, the words will prevail over the figures. So in my example, the court will say, well, it's $100,000, not the $75,000. So you got to be very, very careful when you draft agreements or contracts that your words match your numbers. That's a very, very important thing in any contract, and that's one of the things that I'm always very careful of. So that's all for this chapter. Remember, we do have our exam coming up on Thursday, so please make sure you prepare for that, and I will also be opening up the questions for you to upload on Canvas for these two chapters. And I believe these will actually be uploaded in two parts. I apologize for the delay in getting these uploaded, but this week, for whatever reason, I've had technical issues and have not been able to upload these, and actually had to, unfortunately, had to record a couple of these twice. So hopefully we won't have that problem in the future. We'll see everybody on Thursday. Make sure you bring your Scantrons, please.